Let's talk about our agenda. The agenda today, we're going to start with the law. Where did the history of preventing and protecting certain classes, races, people from harassment and discrimination? So where do the laws originate from, how they progressed through time, and where we are today? Then we'll talk about the actual definition of harassment, discrimination, examples, what it looks like, what it feels like, who can be discriminated and harassed. The next module will be about bullying. There is some, definitely certain types of bullying are seen as harassment. So we want to make sure managers have the tool of, one, not knowing when they could be a bully, correct? But when they see bullying in the workplace, making sure to hit it head on and have those tough conversations that maybe it's not bullying, maybe it's just conflict resolution, and how to have that conversation with the two people that are having the disagreement. So we'll show examples of that. We'll talk about the impact. So now that we know what it looks like, we know that harassment and discrimination are in the workplace, but what is the actual impact on the employee, the victim, the co-workers, the witnesses? What are the ramifications of a company that goes through an investigation? You know, how all of those things play into the workplace and the decisions that we make. The next module is prevention. Again, now that we know what it looks like, how do we prevent it? How do we investigate? How do we be proactive in our manager style and have those conversations when we see something being inappropriate? So maybe gossip in the workplace, or dating, just a joke that took too far. So as a manager, how can you step in at the right time and try to avoid a claim or a charge from taking off because you were able to have that conversation head on. And the last module we'll talk about is correcting. So when we do have to have those conversations, what's the appropriate way to do it? How do you make yourself not only, in my eyes, not only the manager, but a friend, right? Because you do want to have that trust, that credibility. You want to have the type of relationship with your employees that they can open up and be honest with you and feed you information that you might not be aware of, right? Because you're not there every day. You're not maybe seeing certain things, and you need to be told when things are happening and when inappropriate behaviors are taking place. So how do you correct action? That's by educating your employees, educating yourself, bringing awareness to the organization, to your facility, whether it's a location or a department, and lastly, leading by example. So we'll talk a little bit more about that. A friendly reminder, this is a safe environment. You know, I hopefully will have some engagement through the chat, giving examples, asking questions. You know, we definitely want to keep confidential information just as it is. It should be confidential, right? So please don't include names. If you do have examples that you want to share with us, making sure that, you know, maybe you're making it a little hypothetical where people cannot figure out who it is in your organization, right? But examples are the way we actually learn. And so there could be some case law, but really I'm going to use a lot of examples from my 15 years of experience, right? Being both a manager inside, and then obviously my experience here with AlphaStaff of being able to guide and advise my clients their experiences. So again, you may not agree with a lot of these things. You might say, you know what, to me, that's not harassment, that's not discrimination, and that's fair enough. But, you know, again, we do need to be objective. We need to try to stay factual. It's my responsibility, it's your responsibility, it's how we're going to be compliant with the law. So, you know, kind of certain situations we agree to disagree, and that might be the situation that you encounter sometimes, right? Especially as a manager. A lot of times there is no right answer, right? A lot of emotions are here, and that comes into play when we have these discussions or conflict. Why are you here? Most likely you're here because your supervisory manager said, hey, you need to take this training, right? California does mandate it. So there's certain criteria, as you see, businesses in California that have more than 50 employees. If you're a supervisor or manager at your organization, you need to be a part of this. The California Fair Employment Housing Act, they are the ones that set these standards for every 2 years. You've got to have 2 hours of classroom or other effective interactive training. New supervisors need to have it within 6 months. So there's obviously some guidelines, but more importantly, hopefully you'll learn something. You'll take away that your role is very important. You are, as a supervisor, manager, team lead, whatever your title is, you have a lot of authority. You should be leading by example. You could be seen, or you should be seen, as a change advocate for your organization. And whether you like it or you don't, or you're not aware, your employees probably rely on you for a lot of information, right? They don't know the employee handbook. They don't know company policies sometimes, and they're looking for you to see what you're going to respond to, how you're going to respond. Is this a big deal? Is it not? You know, what is my behavior, right? How should I behave? So that's how you play a very important role, that you need to know what discrimination is, what harassment is, what it looks like, how to have that conversation, how to correct it, a lot of that is why you're here, because we know if we can train a supervisor or a manager, they can lead by example and be aware and acknowledge that there's something happening and have a discussion right away. So it kind of trickles down, right? So that means you need to educate your employees. And a lot of that could be through a classroom setting, or it could just be by leading by example and pointing out that their behavior is inappropriate. After completion of this training, you'll definitely understand what harassment looks like, who can be a victim. You'll be able to identify and address inappropriate behaviors. You'll know how to avoid illegal conduct through documentation or through counseling. You'll know how to manage and be proactive to create a welcoming, harassment-free workplace. And you'll definitely know how to respond, how to investigate, what to say, what not to say, sense of urgency, and going through those steps in order to protect you and the organization. Now, I'm not an attorney. I have a lot of experience as HR, so I've seen a lot. I've been through a lot, but obviously, AlphaStaff is here to advise and give you some guidance. So definitely use us as an outlet. But when it gets to something where, hey, there's definitely some legal advice needed. It's a slippery slope. It's very complex. We definitely want to get our legal team or your legal team involved. So take it for what it is. This is good HR guidance. It's best practices. It's real life examples I think everyone can relate to, but it should not serve as the end all, and this is how I behave and this is what I do, right? You've got to kind of take all the situations and examples and look at the whole picture and then apply appropriately. So part one, the law. Let's talk about the California and the federal law, because in California, we've got to think of both. So here's kind of the historical to date of how we got to where we are. So in 1866, the Civil Rights Act was created, and that said, hey, all men, regardless of race, have the right to buy property. So again, you see men, right, not women. So then, in 1964, it was kind of like, hey, what about different sexes or different religions? They need to have civil rights too, right? So that's Title VII, 1964, which is really kind of the foundation of the harassment and discrimination laws. It's probably the most common, and that's where you cannot be discriminated against depending on your race, your color, your religion. You cannot be harassed. It makes it illegal, and that's where the protected classes were kind of formed, which we'll talk about in a little bit. Then in 1967, we have the age discrimination, where, probably what was happening is people of age, and when we say age here in a legal ramification, we mean the age of 40, they might have been not able to obtain employment, or they were being turned away for job responsibilities, job advancement because of their age, right? So it was taken note somewhere in the agencies, the federal government, and said, hey, we need to protect people above the age of 40. In 1990, the same thing with disability. So again, as we're getting to be a more diverse, we're getting more progressive, we're seeing different changes in society. It's more accepting now to be of age, right? Or to have a disability, or at least it's trying to be more accepted, right? And that's where these laws are coming in. So someone said, hey, people that may have only one arm, someone in a wheelchair, someone that with hearing loss in one ear, they're disabled, right? But that doesn't mean they can't do their job. So in 1990, that act, the ADA, which is very known for, said we need to protect that type of group from harassment and discrimination. In 1993, agencies, government, someone took a look and said, look, really, there's a lot of people interacting, and it's really the organization, the company's responsibility to make sure that their employees are safe and they are working in a place that's free of discrimination and harassment. And that's where this came about, where it's like, hey, you've got to take the ownership, right? If there's an issue, you need to listen and resolve it, whether it's through an investigation, whether it's through training, but you can't just ignore it, because now you're going to be on the hook for something, right? So that's where that came about. And then in 2000, USERRA, most likely with the Iraq War and a lot of the people coming back into civilization that were serving, they might have been experiencing harassment, discrimination, not being able to be hired. Maybe people just didn't feel like they did the right thing, right? So they're being looked down upon, and so it's like, hey, we've got to protect those individuals that are coming back, trying to get back into society, served our country. They have rights too, and in addition, if they're doing active duty and then they're called back, or reserve duty and they've got training, we need to be able to say, hey, they can leave for a certain amount of time and their job is protected. They can come back and get work at the same establishment. So that's where the Uniformed Services Employment and Reemployment Rights Act, USERRA as we call it, was established and created. Sexual harassment in general, I'll talk more specifically with California. We have AB 76, which again made the employers liable. We'll talk a little bit more about that, but employers and supervisors at some point could be liable, and will be, if they do not do anything, if they know what's going on and don't do anything, if they don't respond. So that's why this training is very, very important. And then the code that we talked about earlier, 12950.1, that's where anyone that has 50 or more employees needs to provide this training every 2 years and every 6 months to new supervisors. Let's talk about the definition of a supervisor. What exactly does that mean, right? So it's someone who recommends, directs, and has a tangible action, such as demotion, termination, disciplinary action. So what's important to remember in California is that somebody could not have, or does not have to have, a title of manager, supervisor, director, some of those higher level titles that we're very familiar with, to be a definition of a supervisor. This is the EEOC definition, which is the federal agency. But in California, the DFEH, they say anybody who really does recommend or has a decision in someone's demotion, termination, write-up, part of their schedule, that anyone who has that capability is really a supervisor. That in California could be a shift lead, a team lead, an assistant, lead, anything with, usually lead is kind of the terminology that's used in California, but I want you to make sure that you understand that person, if they do, again, have that authority to make recommendations and decisions that can impact someone adversely, they can be considered a supervisor and could be held accountable. That's really important. So let's talk a little bit more about the largest charge of discrimination, where I ask questions. But we'll go ahead and skip that and wait to the next one. The largest charge of discrimination and harassment continues to be, this is a little old, but checked my statistics yesterday, and retaliation is still number one. Retaliation is a form of discrimination, which we'll talk about a little bit later. So again, as we go through this training, you'll understand exactly what that is, how to avoid it, and really, you can see all the other ones play a big factor, but day to day and the number of cases that are getting brought up, it is someone who feels like they were treated unfairly, then had something happen to them. They were demoted, they were fired, they made a complaint, right? And then they were fired or taken off the schedule. That's retaliation, and they're forming a claim. So that's kind of where we got to the statistics today. Talk about federally protected categories. So when it comes to discrimination and harassment, there are protected categories that we have to be aware of. And as a manager, you've probably heard these a lot, or at least maybe someone at AlphaStaff, your HRIM, has asked, hey, how old is that individual? Or, what's their, are they in any protected categories? What's their race? Before they start asking more questions about discipline. And the reason why is because this is the list of federally protected, the federal government says, hey, these are the people that are most likely to be discriminated or harassed. So we're going to put them in their own protected class, right? And so when you are making any kind of decisions, whether it's hiring, firing, disciplinary actions, you've got to keep these in mind, that your decision was not based on any of these reasons. Your decision was based on a business need, a skill, a tangible reason that would impact the business, right? It was nothing to do with because they were female, or I didn't hire that work person because they're pregnant and I know they're going to leave in 6 months, right? Those are the type of things we're talking about here. Now, California, of course, being California, I love California, by the way. I've been here my whole life. They always do things really differently. The avocado heads, they call us on TV, right? We have a lot more, right? A lot more protected categories that we have to be aware of. So not only do we have, a pregnant woman, but we have childbirth. So, childbirth could be seen as a disability. And if that person cannot come back to work after, their normal maternity leave, I put normal in quotes, but obviously there is, different variable deliveries and childbirth experiences, they could be disabled and protected in California. Breastfeeding mothers definitely are protected in California. I'm excited to say, though, that I've seen more lactation rules and protection going around in various states. So that's a good thing. We were kind of also leading the charge with HIV and AIDS and gender. We were kind of the first people to say, hey, this transgender thing, and someone can identify by who they really feel they are, not by who they were born with, or the gender they were born with. That's a protected class as well. And then lastly, if you are associated with someone, or someone even thinks that you're associated with a protected class, you yourself are protected. And that's pretty scary. That's a little daunting, but if somebody, let's say if you're an employee and you're married to someone of another race, and your employer knows about it, and they discriminate you because of that. It has nothing to do with you. It has to do with who you're affiliated with. That would be an example that we want to be aware of, and obviously, not discriminate or harass, that is. So when we have discrimination, we've broken it down by different things, just to kind of give you a look. Trying to look at my graph here. It looks like the largest is the family care, right? If I'm getting that right. Oh, sorry, retaliation. There's 2 yellows. So going back to my original slide, this is California specifically, right? Retaliation is still the #1. So we have federally, retaliation is a #1 claim, #1 charge, and so in California. So very rightfully timely for this training, right? Because it's continuing to happen. So if you guys could type out, employees or job applicants who believe that they have been illegally harassed or discriminated have how much time to file a complaint? And the DFEH, if you remember, is California. So how much time does somebody that feels like they've been, harassed or discriminated against, how much time do they have to file a complaint? If you guys could type it in, that would be awesome. Anytime, okay. What else do we got out there? I feel like my participation is going to go up with this chat box. 30, oh boy, 30. I hope not 30. Is that 30 years? 1 year, 1 day, 3 months, 2 years, 90 days. Awesome. 10 years. You guys are great. So the answer is 1 year. So those who got it, good job. So just, this happened to me. I'll give you kind of a scenario where I was tasked to hire about 100 people for a new hotel that we were opening in Hollywood. And about 6 months later, we got a charge that I did not hire someone because of his race. And it was really difficult for me to go back because, of course, I didn't remember the name because I probably interviewed at least over 500 people for these 100 spots, right? And it was pretty challenging. So a note to self when you're interviewing, definitely take good notes. Put down why you didn't hire the person. Luckily, I came back and I found the paperwork because I was really good about that, and was able to respond back to the complaint that, hey, this person was not hired, was not hired because of this. It's because he couldn't drive a stick shift. That was the one of the conditions. You were a valet driver and you had to be able to drive a stick shift, and he could not do that. So just keep in mind that just because they walk out the door doesn't mean you're off the hook, right? They can always come back for certain things. All right, so remember too that as a harasser, they can personally sue in civil court you as well as their employer. So we'll talk a little bit more about this, but it's just, as a supervisor, as someone who's an advocate and a representative of the organization, your employees look to you. They always come to you for questions, for answers. They don't know what's in their handbook. They're looking to you to advise them and to lead by example. So it's really important that you understand this more than anyone, right? That you need to protect the company and yourself because the employer could be personally responsible. All right, so let's start again with the chat box. Number 1, true or false? A customer or a vendor can sexually harass you. What do you think? I haven't even gone over this yet. True, false, yes, true, yes. Good, yes, true. A customer or a vendor can sexually harass you. We'll talk about that next one. So good, I didn't even go over that yet. You guys know it. If you have the authority to recommend, number 2, you are defined as a supervisor in California. True or false? True, great. You guys all got that one. That was just spoken about. Number 3, the most popular discrimination is in the US is retaliation. True or false? True, very good. It is true, as we learned just recently. And federal law has more protected categories than California. True or false? False, good. All right, you guys didn't get tricked. Awesome, okay. And then last but not least, we obviously just went over this, so we should get it all right. You have 1 year to file a complaint if you believe you've been harassed. True or false? Making sure everyone's paying attention, and they are. Thank you. All right, moving on to part 2. Now we're going to really get into the definitions of harassment and discrimination. I'll give a little break for questions, if any, but of course, type them in as we go along. So harassment is the unwelcome conduct. I think that's what we're most familiar with, right? It's someone who feels like they're being treated unfairly, and it's maybe because of their sex or their religion, their race, kind of, again, personal, some type of protected class. Could be a belief, right, that we're maybe harassing someone, but really that's not the legal definition. The legal definition is that unwelcome hostility, pervasive or severe action that is a protected class. And it's usually a condition of employment, which we'll talk a little bit more about, that if you don't do this, this will not happen. So if you do not, well, I can always think of the sex ones. If you don't sleep with me, you're not getting a raise, right? That's kind of the most common with sexual harassment. But obviously, that's sexual harassment, not harassment. But you see what I'm saying? There's a condition of continued employment, right? So that's one area of harassment. And the second one is that it's hostile. It keeps going on. And so maybe these are comments, these are jokes, these are pictures that we are exposed to every day. And it could just be a normal conversation. We don't mean it to be harmful, but it is, okay? And again, it's towards those protected classes, right? That's the legal definition. Now, someone could be harassing you by just being rude and disrespectful and inappropriate, but that probably won't merit a lawsuit, right? That could be bullying, or that's just bad morale and bad culture, okay? And that's a totally different thing. So we're talking about in the legal ramifications here. Discrimination, on the other hand, is the treatment or consideration based on those protected classes and that there's been an adverse impact, right? And so again, it's not based on an individual merit of performance, skill set, traits. It's all based on you got promoted because you're white just like me, or I'm not going to give you that position because you're pregnant and I know you'll leave. You know, I gave that example earlier. So again, that's making a, you know, I'm writing you up because you are affiliated with this group of people that I don't agree with, right? So that's the difference between discrimination versus harassment. Now we have sexual harassment in its own little category. And again, it's just like harassment, but obviously it's geared towards more of a sexual nature, right? Innuendos, requests, favors, touching, you know, those personal things that all have to do with sex. And so it's unwelcome things like that, inappropriate, unwelcome behavior. And also it's just like harassment, where it can be a condition of employment, which we'll talk a little bit about because there's two types of sexual harassment. Or it could be just that hostile environment that you're being exposed to, and it's starting to wear you down, and it's creating mental issues, you know, physical issues, performance issues, things like that. Again, we'll get into more detail. I'm just being a little broad at this point, but those are the two definitions, right? Let's go back to the two types of protection just to remind you. We have the federal, right? And then in California, we have to also think about the state. So I want you to see how they work together. So Title VII on the left protects you from the things that are most common, right? The race, the color, the religion, the things we talked about. And that is enforced by the EEOC. So if anyone is lucky out there that's gotten an EEOC letter, which I've gotten many, it's a daunting process. They're very, you know, particular on the questions they ask, and it's not a fun process, but they're the ones that oversee and prohibit discrimination on the federal level, right? And then the state, California we're speaking about, that is ruled by the California Fair Employment and Housing, and that's where they take on harassment. And as you see, most of them are based on, you know, gender, pregnancy, childbirth, any type of harassment that's offensive, things like that, okay? So those are the two different agencies and how they may or may not work together. Again, in California, because we do everything a little differently, you know, we want to talk about this new bill that was passed. I forgot what year it was now, probably 3 or 4 years ago, the 887, that redefined gender, and it was very groundbreaking. I think some states are starting to kind of talk more about it. But California really was the first to say, hey, you know, we have gender as a protected category, and we really do need to think about what that looks like. And one, it means the identity, how that individual sees their gender, how they express themselves, and it doesn't mean how they were born, what sex. It's how they choose to have their appearance and how they show up to work, right? And then this rule basically requires employers to allow employees to dress consistently with how they identify and express. So in a nutshell, if you have a woman who feels that she identifies more as a man and chooses to dress that way, as an employer, you need to accommodate and support that and make sure there's no hostility, there's no harassment, there's no bullying, those types of things, which I'm sure can be very challenging. I've been very fortunate that I've not had to deal with this yet, and I hope I don't, but I'm sure I will. And I can only imagine how challenging it must be, but it's something that we will probably deal with, at least I will. And, you know, I'm ready for it because I believe in it. I think everyone has the rights, and, you know, we have to accept it, right? Regardless. So keep that in mind when we talk about gender, when, you know, any kind of harassment or discrimination comes up. So let's talk a little bit more about discrimination. So unfortunately, you know, if you think about it, we all have our biased, you know, ideas of what's right and wrong, right? We were all raised different ways, which of course we're all in the workplace together, right? So you've got this diverse workforce, work environment, which to me is awesome. Diversity should be celebrated. It creates opportunities, discussions, progression. It's something that we want to, any successful company should promote and encourage, right? However, when you do have such a diverse workforce, we're talking 4 different generations in the workforce today, right? And we all communicate differently. We are motivated differently. We were brought up differently, okay? So of course it's going to be challenging that someone is going to think that someone in the baby boomers doesn't know technology, right? So just accept that and let it sink in a little bit, but that doesn't mean that we have to allow it to occur, right? We stop ourselves and say, look, people, you know, in quotes, discriminate, right? They have stereotypical thoughts of other races, religions, people, and unfortunately that does hinder our decision-making process at times, but you can't allow it, especially as a manager in the workforce. So when you are addressed, or if you are presented with, you know, some type of challenge that you're struggling with, be aware of it, of your own biases, right? I think that's normal and healthy, but don't allow it to persuade you and make your decision, right? And of course, if you see it occurring in the workforce, the workplace, you've got to stop it right away and have that conversation. And that's kind of where we'll talk about with the correction and the impact, right? When you do see it, how do you address it? What do you say? How do you document? That'll be parts 5 and 6 when we get there. But just want to make you aware that discrimination is, you know, unfortunately, it's a negative thing, right? But it does occur and we have to be aware of it. All right, so let's go to harassment. So we've got 2 types of harassment. We've got economical and environmental. Economical is more of the quid pro quo, if you've ever kind of heard of that. It means it's something for something in Latin, that, you know, something has to occur. It's that condition of employment, right? And so in my examples here, there could be a termination or a demotion, or it could be a promotion and a pay increase, right? And something has to happen in order for that to occur. So that's the first type of harassment. The second type of harassment is the environmental, which is known as hostile. And that's where it could be anyone. So if I go back to the quid pro quo, because only those of authority have the right to say, you get a promotion, you get a pay increase, you're terminated, right? If you go back to the definition of a supervisor, usually that's someone who can recommend or has that power. Those individuals are really the only one that can be accused or charged, right, with quid pro quo, the environmental harassment. This one, the hostile working environment, can come from anyone. And as you see in the next slide, a peer, a supervisor, a vendor. So if you have your UPS guy coming in every day to drop off packages, right, or FedEx, and that person is consistently maybe asking out the receptionist, right, bothering that person, you know, come on, come out with me on a date, saying how pretty she or he is, right, how attractive, that could be hostile working environment, right? And you, as the employer, even though that UPS FedEx guy does not work for you, you have to do something about it. Because if you remember from 1993, what is it? We, as the employer, have to protect our employees, right? And create a workforce that is harassment-free. And so it's your opportunity, your responsibility, really, to say something to that person. And I actually had that happen to me. I had to say something to the FedEx guy. So that's why I always use that example. It was uncomfortable, but, you know, my employee came to me and she was not comfortable and I wasn't going to have it, right? So I said something to him. I told him it was inappropriate. He should not behave like this. If I see it again, I will call your supervisor, just to give you a heads up, right? And it didn't happen again. But that's the type of responsibility, ownership we need to be taking, okay? And then with the hostile, it can be either severe or pervasive. So what that means is that obviously the severe, right? We've got the aggressive grabbing, fondling, you know, when you think of severe, I know there's different levels, but I think we can all agree that, you know, sexual assault, rape, those type of things are very severe. And that's it, right? Those have to be addressed immediately, right? And then pervasive is something, of course, that happens over a long period of time. And so you could have a conversation with someone and say, that comment, that, you know, that action, that behavior is inappropriate. This is your warning. If you do it again, there will be consequences. And you, of course, document and then you move on. And then, of course, you readdress it if it occurs, right? So that's important with the hostile working environment, that there is the severe and the pervasive. Usually with the quid pro quo, the environmental, it's just the severe, right? Because if you remember, there's a condition of employment and there's an authority figure taking advantage of somebody else, right? And so that's usually seen as severe. Okay, so if you guys could get your fingers moving, let's type out some answers. Name that harassment. So we're going to either say, if you want to say quid pro quo and hostile, that would be perfect. The first one, a supervisor tells an employee in his department that she can have a raise if she sleeps with him. Is that quid pro quo, QPD, as someone wrote? Perfect. Quid pro quo or hostile working environment? Great. Quid pro quo. Awesome. Again, remember, supervisor, right? So when you're addressed with these situations, think about who is harassing and who's the harasser and what the situation is. And you can narrow it down right away that this needs to be addressed immediately, right? Number two, an employee refuses a supervisor's sexual advances, which causes the supervisor to negatively alter the employee's working hours. Is that quid pro quo or hostile? Hostile, hostile, perfect. Quid pro quo. So this is kind of tricky, and I've been challenged, and I'm starting to think it's a little bit of both, right? Because obviously my first thing was like, it's a supervisor and they negatively alter the hours, but what if the hours go back up, right? What if there's another, it could be seen as hostile. I think my gut's telling me quid pro quo because that action happened right away and it was a supervisor, but I could definitely see it could be hostile as well, depending on the reason, right, for changing it. The third one, constant use of sexually provocative or obscene language. Is that hostile or quid pro quo? Hostile, right. Good job, everyone. Yeah, so again, the word constant, right? Pervasive, it's constant, it's continuing to happen over and over again. That's absolutely the hostile working environment. And then lastly, the continuous sexual propositions to an employee, even without directly tying the employee's response to an advance of employment. So that's even more tricky, right? They're not saying, hey, if you do this, you'll get that, but they at least keep mentioning it, right? The propositions. That's definitely hostile. Very good. Awesome. Okay. So for those who don't know, which I think most of us know, but as part of the training, we have to make sure we can identify what harassment and discrimination looks like, right? So let's talk about it. So physical or sexual, we have the obvious: touching, pinching, patting, grabbing, maybe requiring someone to dress sexually provocative, right? Maybe to earn some business or something. Hazing, touching, poking, caressing, hugging. Even hugging could be seen as physical or sexual harassment, right? And again, in a lot of these things, that could be, I guess when I say hugging and touching, how severe was it? Okay, we'll talk a little bit more about that. I think I have a couple slides, but we want to make sure we have the definition of, well, he touched me, that's harassment. Well, is it really? Let's talk a little bit more about the touching. What happened? So I'll give a better example as I go through. But that's the examples of physical and visual. Then we have sexual, right? Which again, very obvious. Unwanted intercourse, kissing, exposure, pictures from emails or love letters, referencing people's autonomy, talking about sex lives, anything that really is in sexual nature and provocative and suggestive, that is considered and can be considered sexual harassment. We also have verbal we got to think about, name calling, which, could be bullying, right? But depending on the name, belittling someone, again, the sexual explicit jokes, any kind of comments like sweetie, honey, boy, girly, something as simple as a cell phone ringtone, maybe you have Baby Got Back on your phone and it rings and the whole audience can hear it and someone is very offended, right? So comments like that, little things like cell phone rings, calendars, pictures, jokes, emails, all of those things could be considered verbal harassment. And then we have visual, which again kind of goes, you kind of see they all kind of play into each other, but inappropriate emails, internet use, I think that's probably something that we deal with, hopefully not a lot, but I guess just with technology, right? It's very easy to spread a comment or a picture very quickly to a lot of people, right? Leering, so looking at someone that makes them feel very uncomfortable, staring at their, their chest or their legs, things like that. Those are all considered visual harassment. Some examples that you might not think about, there's been some talk recently about, changing the Redskins name because it could be offensive, obviously, to the Native Americans, I should say, sorry. And, someone who has this maybe in their office, right? They're hard, what am I trying to say? They're a heavy Redskin fan, but diehard, that's what I was trying to say, sorry. Diehard Redskin fan, they have all their stuff hanging in their office, but then someone's offended, right? And you as the manager has to address it. I mean, how uncomfortable and how awkward, right? Because the person doesn't mean anything by it, but unfortunately, their display of their t-shirt, right, or their NFL team could be seen as harassment to somebody else. And really, the way you address these is, hey, don't change who you are, just don't bring it into the workplace. A t-shirt like this does not belong in the workplace. It's not professional, for one. And, we want to keep our decorations in our office, friendly and, not open to misinterpretation, right? I mean, those are kind of some conversations to me that are very simple. So what is discrimination? Going back to, we kind of talked a little bit about the definitions on the harassment. Let's talk about a little bit more about discrimination. So it is an unlawful employment discrimination. And it's something that's based on one of those protected classes, right? And so when I say that tangible action, I think I mentioned in the earlier slide, these are some of the decisions that you guys probably make every day, right? Allowing time off, making schedule assignments or changes to the schedule, terminations, hiring someone. I mean, these are simple things that we do. Sometimes we don't even think about, right? But if you don't think about it and you're making the wrong decision for the wrong reason, they can come back to bite you. So really what we're going to talk about in the next couple of modules is that when you're making these decisions, you have to document the reason why. And for me, the most important thing is be transparent about it and tell the person, because that's where we get into trouble. A lot of times we don't tell the people why we made these decisions, or we're vague because we don't want to hurt their feelings and we're nervous about what to say. But really, to me, transparency is the best. You've got to be upfront and honest and tell them it's because of your performance. Or the reason I'm not allowing you time off is because you took all this time off there, and that's why I'm allowing someone else to take the time off, now instead of you. Like, being honest about it so they don't think, oh, it's because I'm going to church, and they don't agree with me going to church on Sunday, right? They get in their head and they start making up reasons. You don't want that to happen. You want to be in charge and make sure you tell them why you made this decision. Very important. Let's talk about different types of discrimination. We have the adverse impact and the disparate. And the adverse is really something like maybe a tool that you're using that appears neutral, and maybe you're screening out certain people. Like, most common is kind of a pre-employment tool, and not even knowing that you're adversely affecting a whole protected group. And this came out, I think, a couple years ago, maybe even 10 at this point, where an agency was using a behavioral test, and they found out that all the Hispanics were scoring very low, and it was adversely impacting them, and they weren't getting hired. And they didn't know why, because they had this tool, and they're like, well, wait, this tool is great, right? It's helping us make the decision, but really the tool was hurting them. And then Jeff had a question. Does seniority play a role? Absolutely. Seniority does play a role when you want to give time off. You should definitely use that and just make sure you're being consistent, right? That's the key. We'll talk a little bit more about that. So then we have the disparate action, which is basically you're really intending on taking out a whole class, right? You are looking at someone, you're applying something specifically. So an example of this would be background checks, or putting something on an application like, have you ever been convicted of a crime? Which I think we all know now, right? The ban the box, we've heard of that. That is exactly why that law was created, the ban the box, because so many people were just seeing that, yes, I've been convicted, and not even asking questions, right? They were just, oh, we're not going to hire you, you're not going to be considered. And it was definitely impacting that whole group of people and not allowing them the opportunity to be, re-engaged in the workforce and allowing them that second chance, which is really, kind of what we should be doing, right? So those are the two types of discrimination to be aware of. We can't talk about harassment without technology, right? Because we're using technology today, of course. And there is so much going around, and as I mentioned earlier, it's so easy to just hit send and not even understand the ramification, right? And a lot of people think, oh, it's going to be deleted. I can just delete that. And I think we all know now, right? Nothing is ever deleted. It's in the cloud, or, our IT team has the capability to pull it back and show it to us. So, my recommendation, to this group especially, is if there's something really sensitive that you need to talk about, especially with an HR person, or, even, I guess not legal, because you'll have that confidentiality thing right there, but anything that you're kind of considering that you need some advice on, and you don't want that trail to be had and like pulled up later, pick up the phone. There's certain things that you might just want to talk about and dissect and roadblock and be honest about, but you don't want it in writing, right? So that's kind of my disclaimer there, at least from the HR standpoint. And then just remembering, that there is a form of harassment with technology, and just because it is delivered via email, a video or whatever, it can still be used against the person, and then obviously it's still considered harassment, right? And then does it have to happen at work? So a couple of questions come up where, we had happy hour, it was a Christmas party, and someone got inappropriate. They got drunk, they got inappropriate, and, behaved in a way that was very disrespectful, borderline harassment. What do I do, right? And the answer is it doesn't have to happen at work. It's going to vary, of course, from different experiences and the environment, but obviously if it's a paid function, which may be a team building or something like that, obviously that's pretty simple, right? But the statistics and claims that have been filed and advice that's been given, even though it is maybe a work function that is off the books, so happy hour, Christmas parties, if there's any type of harassment going on, or I guess not really discrimination, more harassment, definitely if the employer finds out, they need to do something about it, even if it was off work, right? I know this example is more of the one I told you about the UPS, but just want to throw that out, that, if Monday morning, one of your employees come back to you and say, hey, we were all out for happy hour on Friday, and John got really inappropriate and showed us some dirty photos, I was really offended. I just want you to know, you need to do something about it, even though it was happy hour. There could be different things that you're going to do about it because it wasn't on work property, but a conversation definitely needs to be had, because there was enough people there that it's a group environment, a work environment, and the employer could ultimately be responsible for it if they knew about it and did nothing. Okay, so keep that in mind. What is unwelcome behavior? Again, I think pretty obvious, especially to this group, right? Because you deal with this all the time. But again, as part of the training, you got to know what that looks like. So the most obvious, the employee complains, right? And they come to you with an issue, they have an example, there you go, it was unwelcome. But, as a manager, and even, obviously there's only managers on this call, but as you're educating your team, it doesn't have to be verbal, it's body language. So as you're going back to your team and hopefully telling them what you learned and reminding them that harassment does not exist in the office, in the environment, you do not allow that. And if somebody says something inappropriately to you, or if you say something inappropriate, look at their body language, because they may not say anything. They might be embarrassed. They may not want to make a big deal. They may fidget. They may roll their eyes. That is all signs of unwelcome behavior, right? And so if you, especially as a manager, see that, you need to walk right up and say, hey, pull them aside. I noticed that there was some talking and your body language seemed to change when the conversation started getting about politics, right? And there was maybe comments about the Muslims and all the things going on with the immigration, okay? This is typical, water cooler conversation, right? It's in our news every day. And so, if you were maybe as a manager to see that and you saw somebody get uncomfortable, you could go up to them and ask them, and then of course you would address it with whoever made that comment, that, concern or whatever. And again, I'm not saying you can't talk about these things in the workforce. I'm saying when you see someone feel uncomfortable, the best way to handle it is, hey, while it's not illegal to talk about the immigration and Trump and all the things going on in the world today, it's definitely probably not the best place to talk about in the work area, right? It's distracting, it's very uncomfortable, it's polarizing, it's just something that we don't need to do at work. If you want to take it on your break, great. But it does make people feel uncomfortable. And so keep that in mind, right? That's the type of conversation I would have with somebody who maybe started that type of, comment at work. So this is unwelcome behavior. Who are the potential harassers? I think we already talked about that, right? Really, it could be anyone. And of course, the employer is liable if they knew about it or should have known. So that's key too. I mean, if there's enough evidence that you should have known about it, just because no one said anything, you're on the hook, And so of course, if you fail to stop it, you're definitely on the hook. So keep that in mind, that as a supervisor, you are aware of what's going on usually. You hear things, you see things, you gotta make sure and address it and then follow through. Who's the victim? There could be several victims here. There could be the witness. So maybe it was just, again, that comment and I just witnessed it, but that comment towards, people of a minority is disturbing to me, and that made me feel very uncomfortable. So I witnessed it, right? The target themselves, maybe somebody who, if the comment was about gay marriage and that person is in that type of relationship, they were the target, they would obviously be a victim. And then there could be the third party where, pretty common, people are joking, they're talking, casually, of course, and then someone is in the conversation and just doesn't even, doesn't seem to care or was unaware of it. The group didn't know that person was offended, right? So those are, and that's kind of more of a witness, I guess, but those are very common, right? And so again, just because they weren't a target, they do need to be discussed. They need to be maybe investigated depending on the severity and what you find out when you have a discussion, and definitely addressed to make sure it doesn't occur again. Who's liable? The employers, as we've been talking about throughout the training. Again, for the two different ones, the quid pro quo or the hostile. And again, the employers are liable when an employee suffers that, write-up, termination, demotion, some type of employment action, and it was because of a supervisor's conduct, okay? So that's when they are liable, when the employer is liable and they don't do anything about it. Supervisors are liable when they fail to respond, they engage, or they don't monitor complaints, okay? And really, again, going back to California, in California, this is where supervisors are liable. And of course, this is a California training, so that's why we go over it. And the reason they're liable, along with the employer, is because they're considered an agent. They should be upheld to, a pretty high standard. They should know better. They're abusing their power, and they're not really doing anything about it. They're an advocate for change, right? And they have the ability to change something, and they're not doing it. Another way to look at it, just again from a perspective of who's responsible and the employer, really it's again when the employer did nothing about it. So what I hear a lot is someone gets terminated and now all of a sudden there's a complaint of harassment, right? And they want to bring a charge, or they do bring a charge. And unfortunately, they never said anything while they were employed. And so, of course, you're thinking, well, it's probably because they were terminated, right? Which is probably pretty true, but we still need, in my eyes, especially if there's a charge and from an agency that they're wanting to investigate, we need to look into it, right? And so, from that standpoint, when agencies look at these types of charges and claims, they're going to say, well, did the employee really give the employer the opportunity to make a change? Did they notify? Was there evidence, things like that? So that's what they're going to be looking for liability. So if the employee didn't give the opportunity, most of the time, the employer's off the hook. Because if you didn't know, if it wasn't obvious, you can't change something, right? I mean, you can do trainings and you can have conversations, but until you really know what's going on, you can't really fully investigate. You can't have certain conversations and stop inappropriate behaviors if you don't know they're happening. Okay, so that's a little bit where there is a relief for the employer, but usually the employer is always liable because they should have known, they failed to investigate, they didn't do a good investigation, they didn't document, those type of things. Type in what type of harassment. So again, we have the hostile or the quid pro quo. So we have Sam. Sam is Melanie's manager. They're working together. They're having dinner because they're working long hours. And after dinner, he says, perhaps if we collaborate well on this project, I can make things easier for you at your next evaluation. And of course, his tone insinuates what is meant by collaboration. Is that quid pro quo or is that hostile working environment? Quid pro quo, great. I love how everybody just types QPQ, that's awesome. Quid pro quo, absolutely, right? Because he's saying, hey, if you want to get a great evaluation, you gotta, I don't know what he's saying, but you know what I mean. He wants something, right, in return. That's not appropriate. Okay, so which type of harassment? Peter and Josh work together. There's all types of races and ethnicities. Their supervisor continually refers to the Latino employees as beaners. Peter and Josh are white, they've complained, but the manager says, hey, you're not Latino, so why does it bother you? And I'm not gonna do anything about it. I'm not targeting you, get over it. What do you think that is, hostile or quid pro quo? Very good, hostile. And remember, going back, these guys have as much right in California as, the Latino group, because yes, they're not the target, but they're a witness, right? And it's uncomfortable for them. And anyone who's uncomfortable, that could be a sign of harassment, not just in California, but obviously everywhere. So another typical one I see a lot, John, who's 54, he's had great reviews. Maybe there's some new technology that rolls out, or all of a sudden he's not keeping up with the younger group, and he's often called slow and sluggish. That's the common theme going around the office, right? But he's been a great employee. But after a year, they fire him for not being a good cultural fit, which I see a lot, right? He's not fitting in with our culture. What type of harassment could this have been? Hostile or quid pro quo? Hostile, very good, yep. Because it happens over and over, right? And there's no supervisor here, I guess. I mean, he obviously got fired, but absolutely, it's just the way they're, plus discrimination for age. Thank you, Tim, you're absolutely right. Yes, I mean, obviously he's over the age of 40, so he definitely would have a very good case, right? So it is a hostile working environment. Okay, last one. So Carmelita is an attractive lawyer, right? And her boss says, sorry, I always do guy and girl. I need to switch this up. That's me being a girl thinking it's always men, but you guys know that women can harass men too. So we'll talk a little bit more about that. So, hey, Carmelita, why don't you wear shorter skirts? You're attractive, show off those legs a little bit. I'm sure the customers will be happier, and a little dedication could go a long way. Is this hostile or quid pro quo? And Michael, yes, going back to your question, John is definitely in a protected class. If you were to fire him because of a cultural fit, you would want to have a lot of evidence to show. I mean, one, I wouldn't fire him for a cultural fit. I would fire him maybe because he wasn't doing his job correctly. If there was any kind of skill set that he needed. I would not say anything about his age, right? I would keep it very specific to what he was doing wrong. That would be your protection against age discrimination. Sorry about that. I got carried away and I jumped to another one. So everyone's saying hostile, quid pro quo. Absolutely. It could be a little bit of both, right? I think I put hostile, but absolutely I would say it could definitely be both. I don't know if it's severe enough to be quid pro quo, but, and he's not saying, hey, you have to do this or you won't have something happen, but definitely could be pretty close to both. All right, any questions? We'll take a little, I think I'm doing good on time, 12:01, but questions, comments, everyone's good to go? Taking a drink of water. All right, let's move to bullying. Thou shalt not bully. So bullying is another form of harassment. As you can see, these are older statistics, so they probably have increased since bullying has gotten a lot more common. And I'm almost wondering when they're going to start talking about cyber texting and cyberbullying, because I could definitely see that being a new topic, right, that we haven't really talked about. But as you see, most people are aware of it or they've been bullied themselves, right? 20% unaware, that's, it's kind of, I don't know, maybe that's, I guess it's obviously a statistic, but I think most of us now are pretty aware that it does happen and it is another form of harassment, right? So in 2015, which I guess those statistics were old, so maybe that's why they put this out here, right? In 2015, they added this part of the training to the already scheduled harassment and discrimination training that all of California had to do. And so as part of it, we have to talk about abusive conduct, which really is bullying. So some examples of this. We have repeated derogatory remarks or insults, verbal or physical, sabotage, you're undermining the performance of someone. And really the most important thing is a single act does not constitute abuse unless it is severe and egregious. So a lot of people, I get a lot of comments about how my boss is a bully. He mean to me, he was blunt, he was direct, he yelled at me, things like that. And really that's not illegal. Your boss can yell at you. I hate to say it. Is that right? Absolutely not. That's not right conduct, right? We don't want to behave like that, especially a boss. But in the legal ramifications of abusive conduct, it's probably not going to fly, right? And so it's inappropriate. It needs to be addressed. But these are the examples of abusive conduct, which really is bullying, okay? So knowing that, we have different types of bullies, which I'm sure you guys are all aware of, right? Maybe we have the substance bully where, someone's obviously abusing alcohol, drugs. These could be prescription, right? Because as we know, there's a huge issue with that. They're coming to work, they're a little number, maybe their decision-making is not the best, and they are, making comments and maybe being a little bit more aggressive, right? Because they're on edge. Maybe they don't feel good, right? So that's kind of the bully there. The opportunistic bully is one that takes advantage of a situation, right? They usually prey on the weaker or the more timid, and they swoop in and see an opportunity and, cutthroat kind of environment where they want to make themselves look good and undermine the performance of someone else. The accidental bully, this is probably the most common, where someone doesn't realize that their behavior, the way they communicate, the way they address an issue, maybe they let something work up to the top and then it blows and they kind of just take it out on the individual because they feel like, especially in a supervisor position, right? I feel like I've told you this several times, like this is the way it needs to be done, or we've had this conversation more than once, I'm so frustrated. And so they accidentally get a little aggressive, right? So that's the type of bully that they're talking about there. And the chronic bully is just what it is, a chronic bully. They're just, kind of a little bit maybe of the opportunistic where they just don't care, they're taking advantage of something if they can, but they're really just, that's their type of management style. Right? Or I guess this isn't really a manager, but this could be just a coworker. They just bully people, they intimidate, they always want to be right, they have to be in charge, and the way they do it is very disrespectful and can be abusive, on that borderline of abusive conduct. So when we have examples of bullying, we do have cyberbullying here. That's great. I did have it in here. I forgot. So we have text, we have social media, right? And then the more normal, the physical, the hitting, kicking, verbal, social. Maybe you're not inviting people to lunch. You're not inviting people to happy hour, things like that. Those could all be seen as examples of bullying. So as a manager, if you hear about it, definitely if you see it, you want to obviously address it right away, get to the bottom of it, talk about it, and then, resolve it and document it. So how do you know if it is conflict or bullying, right? And so the example would be, is that a conflict, like I said earlier, a conflict to me is healthy. It creates dialogue, it creates different ways of doing things. Unless you talk about things, sometimes things always stay the same way, right? Challenges are good, and it's an opportunity to continuously improve something. And so it's really a disagreement, and both people want the same result, but they're just struggling getting there, right? But bullying is where usually one has or is perceived to have more power. They do it in an intimidating, a hurtful, a harassment type of communication, and it's often repeated. So that's kind of how you can say, at least from a manager perspective, if someone comes to you and says, I'm being bullied, really what is it? And I would say 9 times out of 10, especially with coworkers, it's just conflict. Personalities clash, the way they communicate, the way they get things done. They're not seeing eye to eye, and it just needs to be resolved that way, right? So how can you handle it? So one, evaluate the situation, ask a lot of questions, what's going on. And from me being a manager before, really what I do is I encourage the two people to get together, right? Let's talk about it. I'm not going to be a liaison for you. You both need to get in a room. I'll be the mediator, right? I'll sit and talk and keep everyone at bay, but we need to talk about what the problem is and why you cannot get along. And so let's be mature adults about it. If you don't like the way I'm communicating, then let's talk about it. Maybe I can address my style. Everyone has different styles of communicating. Everyone has different styles of handling things. And if it doesn't mesh with someone else, that's a problem, right? But unless the person knows it's a problem, then they can't fix it. And maybe they do know, but they don't want to fix it. But this is the most appropriate, I feel, and the most mature way and productive way of getting the groups together to talk about it. You document it, you move on, and you go from there, right? And of course, readdressing it if it comes up again. But ignoring it, not getting to the root of the problem, and allowing it to continue and fester could create harassment, hostility, an unwelcome work environment, and obviously a loss of productivity, right? So as a manager, you definitely need to address it. So again, understanding that when you're getting a group of people together, that everybody, has good intentions, usually. I'm the type of person, I believe that most people want to do the right thing, right? But sometimes we get busy or we get selfish. We don't see other people's perceptions and perspectives, right? We need to start walking in other people's shoes, and then maybe we'll have a little bit more compassion and empathy and realize that this person isn't trying to harm me or be disrespectful on purpose. They just didn't realize what they were doing, right? So these are some steps, at least from my lens, of how as a manager you can handle it. Again, encourage that in-person conversation. You should resist the urge to solve it. Stop being an enabler. Let's help train our employees how to work through these problems, right? It's a skill that needs to be built, and it's uncomfortable, it's confrontational, but hey, that's how they're going to build. That's how they're going to get better as a person, in my eyes, right? So again, this is kind of my philosophy, but that's the way I manage, right? I just really encourage people to take ownership and get to the root of the problem. Let's don't walk around it. Let's confront it head on, and let's move on, right? And as a manager, again, if that's the type of philosophy you want to take, go for it and push it onto your group, right? And encourage them to behave the same way. If not, whatever your style is, again, try to encourage that people in your group will handle conflict a certain way. Or, obviously they can handle it their own way, but as long as it's respectful and productive, go for it, right? So let's talk a little bit about, is this behavior bullying or is it not? Is it just conflict? So expressing differences of opinion, is that conflict or bullying? You can say yes or no. Is it bullying? Yes or no? If you have a difference of opinion. No, very good. Right. Actually, absolutely. Yeah. I mean, differences of opinion should be happening, right? I want to be challenged. If I'm doing something wrong, tell me, help me figure out a better way to do it, or give me a different perspective, right? So that's good. So that is not bullying, at least in the legal eye, right? What about offering constructive feedback? So as a manager, you're giving, you might be giving some harsh feedback that's uncomfortable, but you're guiding them, you're advising them on work-related behavior. Is that bullying? No, very good. And that's really important, because I get a lot of managers that are afraid to talk to their employees. They're afraid to be honest because they're afraid they'll say something wrong. And again, as long as you keep it work related, keep it very objective and have facts, you're fine. You want to do that. You want to make sure you document and have those type of conversations, right? Number 3, what about intimidating a person? Is that bullying? Tim, I love you, Tim. Yes, if intentional. I know I need to put a little thing here because everyone says yes, and I always have to put my disclaimer that yes, it's bullying if it's intentional, right? But there's certain intimidation that may not be considered bullying in the legal eye, but absolutely if it's intentional, yes. So very good. And last but not least, constantly changing work guidelines for no reason. That depends. I love it. Yes, I agree. And it could be, this is definitely a yes or a no. It's hard to say. I think you have to really look at the context, right? If you have someone that might be in a protected class, someone who's had a complaint, you definitely don't want to change. And really, is it a good practice? No, you should have a reason for changing, right? Their work guidelines, because that could be seen as that's an inconvenience, right? One, you're probably not going to have a great employee. They're going to be frustrated. They're not going to be happy, and they're not going to be as productive, right? So really, you need to have a good reason. But I could definitely see that that could be bullying, especially if you don't have a good reason, right? And you don't talk about that reason. Most importantly, you should always be talking about why you're doing things. But in a legal aspect, it probably is not seen as bullying, but it could be discrimination depending on what it is. So, and yes, Joshua, if it's intent to belittle or undermine, absolutely, and to sabotage, I like that. Okay, so let's move on. Now we're going to start talking about the impacts. We've talked about what it is, what it looks like, bullying, but what is harassment and discrimination really do, right? So let's talk about the signs first, which I think most of us know the signs, but sometimes the signs could be hidden and you might not know it's because of harassment. So if you start seeing someone who definitely was a great performer, all of a sudden they're having attendance problems, they're avoiding a certain person or a situation, their performance has declined, they're moody, they're irritable, they're just, they're isolating themselves. Something else could be going on, yes, but to me as a manager, I want to know what's going on. And of course, you have to be sensitive, right? Because it could be none of your business. But I take the perspective of, hey, I want you to be happy. Like, what's going on? Is it something I can help you with? And yes, I'm your manager, but I'm also your friend. So if you are having personal problems, if it's a divorce, childbirth, who knows what it is, financial things, you don't have to disclose those to me, but I would love to be able to know so I can understand and support you better. And maybe if I know you're having marital problems, I won't ask you to stay working all the time late, right? If I don't need you, okay? So that's just an example that sometimes understanding that your employees have baggage and they bring it to work because they're human, right? We can't shove it at the door. We should, but sometimes we can't. Some of those things do come into the workforce. But understanding that as a manager, I'm sure the employee would be very happy to hear that and feel comforting and probably come to you more so, right? Because they know they can trust you and you'll work with them and things like that. Now, that is no excuse if there's no, if they're not performing and there's been issues, I'm not saying that's like the get out of jail free card. I'm just saying to maybe, again, be a little sensitive, put your foot in their shoes. And if they're going through something, it could be something you could help them with, but absolutely in this case, it could be a sign of harassment and you need to start asking questions, right? If they don't tell you, they don't tell you, you document it and you're done with it, right? And you just keep observing. So effects of harassment, I think we all know there's obviously legal, financial, but there's turnover, right? People will leave an environment because of harassment. You always hear the statistic, people leave because of bosses being mean to them or they didn't get along or whatever. They just didn't like the environment, right? Now that's not always harassment, but it just goes to show that in a harassing situation where the workplace is very uncomfortable and inappropriate and just awkward to work in, no fun, they're definitely going to leave. And that means more people coming in, having to retrain, less productivity because new people are coming in, and of course it's very expensive to hire new people and train people. People around you may be working more hours to cover, so now they're upset. Their morale is not very good. They could get injured because they're working longer hours, they're tired, they're not focused and paying attention. And then, of course, if you're a well-known establishment with a great brand and it gets out, that you've had a lawsuit or a claim, and it will, we've all heard it, definitely it's going to be hard to attract, talent, just maybe have people frequent your establishment, it's definitely damaging to the reputation. So these are, of course, all things to think about when, there's harassment going on in the workplace. Harassment on victims, we've talked a little bit about it. Obviously, self-esteem issues, they feel isolated. They probably won't obviously be very productive. They're definitely not going to be engaged. They will most likely be out a lot, calling out because either they're sick because emotionally and physically they can't come to work. They're either scared or they just don't want to come, or they just, said, I'm out of here, and if they're not going to do anything about it, I'm not going to show up, right? So there's obviously a lot of effects that will roll over to the workplace, but that could impact the victim as well. And health issues, health insurance can go up, they're going to be out, those type of things. So as we talk about it, you're probably like, why do people act like this? It's pretty common, right? It's pretty known that you shouldn't treat people like this. And probably the biggest thing is that I didn't know it was inappropriate. I didn't mean to. I was just joking, right? I mean, come on. Like, we're so PC around here. Get a backbone, right? I mean, I hear that all the time. And it's not the right approach, right? When you're at work, you're at work. And you can conduct yourself no matter, whatever you want outside of work. But there's a professional hat that needs to be put on when you're in the office or you're around vendors or wherever you're at conducting your type of business. And these types of conversations, these comments, jokes, pictures, things that we've talked about do not need to go into the workplace, right? And so it's our responsibility as a supervisor to make sure that's not happening and then educate people and hold them accountable when they are coming in, and making sure it doesn't continue, right? But that's why they behave badly, because they're humans, they're normal people, that they just bring their same personality into the workplace. And especially if they've gotten away with it and no one has said anything, they think that's the norm. They think that's acceptable, and they're going to continue doing it. Some more statistics, again, just showing the overall number of sexual harassments are down, but men are increasing to file. So you kind of see some numbers, and again, these are obviously outdated. But we really do believe the reason the cases are starting to get larger for men is because women are starting to take power, right? We have the Equality Act, and more women are being promoted. We have women CEOs, and so they're starting to make decisions. And like I said earlier, and I'll say it in another couple modules, women can sexually harass and harass men, right? It doesn't just have to be the men. Men can harass men, women can harass women. It happens all the time. But these are some statistics to show dollar amounts, 9.7 million in legal fees. It's a lot of money, it's a lot of time, it's a lot of headache to go through a harassment claim. Daily, about 450 are being filed in the United States. California leads the nation, which is why we're doing this training. And a really important statistic, if sued, the company loses 50% of the time. And that's because it is the employer's, the company's responsibility to prove they didn't do it. The employee can say everything they want, and the employer has to say, no, that didn't happen, and here's why, and here's my evidence. So another reason why you always want to document, you want to have that bulletproof evidence, that documentation, that file to show that, no, this employee is not telling the truth. Here's what really happened, right? Otherwise, they're going to believe the employee. Retaliation. So we talked a little bit about it, and for the first time ever, I would say probably in the last 5 years, that this has been the leading type of complaint. It used to be sexual harassment, and now it's retaliation. So we're going to talk about that. So just to give you a heads up, that's why it's in this training, because it is such a my opinion, overused. I hear that word a lot. I'm being retaliated against. Well, are you really? Like, tell me what's going on. People use these buzzwords, right, to get attention. And so that's why it's very important for you to understand the legal definition of retaliation. And Christopher says, does that 59% include settlement to make a case go away? Are you referring to the 50%? Yeah, I don't know that answer. Probably, but my gut's telling me yes, but I don't know, Chris. So I don't know the answer to that one. Okay, retaliation. So an adverse action taken against an employee. This is the definition. Sorry, somehow one of mine's deleted. Sorry about that. Okay, so the definition is an adverse action. So again, an adverse action, which we'll talk a little bit about, taken against an employee who has claimed they were harassed or discriminated. So you have someone that comes to you and says, hey, I have a complaint, whatever, my boss is harassing me, right? You do an investigation, you find out that nothing happened, and now all of a sudden that person is demoted. They're not working for that boss anymore, right? They are doing a totally different job, and they're not doing what they were doing. And there's no reason why. This person could then think that they were retaliated against. And they probably were, unless you have substantial evidence to show that it was a business need or something related to their merit, their performance, things like that. So again, these adverse actions could be a demotion, discipline, termination. So what we're going to do here is really that you want to make sure when there's a complaint, okay, and a complaint about anything, it could be a safety issue. Obviously, we're talking about harassment and discrimination here, but any kind of complaint you want to investigate, and then when you do have to make some decision that's going to adversely impact them, you want to make sure you have a good reason why, and it cannot be tied to that complaint, okay? So that's where the documentation is really key. And in addition, in my belief, being very transparent of why you're making that decision, why you're making that change, because you do not want the employee to think, oh, all of a sudden now this changes because of my complaint I made, and now I'm being retaliated against, okay? So you want to definitely make sure that you're being very clear about that. And so, of course, promoting zero retaliation. So if you are in the area where you oversee a team of managers, you want to make sure you understand why they're making decisions and educate them on the decisions they're making and how they could be impacting, the company if they're illegal, right? Retaliation is forbidden, obviously by you, the manager, by the alleged harasser, so that the harasser can't go back and retaliate, by any other supervisor or coworker, against any person complaining, which we already talked about it, or someone even participating, right? Participating in that investigation could be retaliated against. And then also the innocent employee to punish another worker for complaining, right? So obviously a lot of touches with retaliation. So again, the best practice, which is, I believe, the next slide, in order to succeed in a retaliation claim, because we know they are prevalent, they are the most common, you want to make sure that whatever that protected activity was, which harassment is one, it could be get a safety complaint, things like that. Any kind of protected activity, that whatever the adverse action was, they are not linked. That's what you need to prove in order to win a retaliation claim. So again, it's on the employer that they have to prove that, okay? So bottom line, if somebody did something wrong or made a complaint, brought something to your attention, now is not the time to change things up in the organization. Get rid of them, demote them, decrease their pay. You don't want to do that. So an example would be someone tells you they're pregnant, right? And now all of a sudden they were in line for a promotion, and now they're not going to get it because you found out they're pregnant. And your excuse could be, well, she's going to be on maternity leave. I'm going to need her around. And depending on the validity of that, if you could really prove that you're going to need that person around, that could be a form of retaliation by not giving her that promotion, because pregnancy is a protected activity, okay? So how to avoid a lawsuit, and Richard, I took note of your question, so I will definitely find out the answer for you to the question I did not know, so thanks for asking. Okay, so to avoid a retaliation, you want to educate yourself and your employees. So remember, when I say your employees, really, when I say educate your employees, if they come to you with something, explain to them that's not retaliation. Let's educate our staff on what harassment is, what retaliation is, so they don't just use these words, because the words they use are very, they're nerve-wracking, and to me, when I hear harassment, hostility, retaliation, I drop everything, right? I see those as very severe, very urgent, and I need to figure out what's going on and investigate, right? So when I do the investigation, I always remind them, hey, just, FYI, just to let you know, that is not a legal definition of harassment. Here's what harassment looks like. And in this case, retaliation, right? So the more we can educate people, the less likely we will have fraudulent claims, I believe. So, again, that's just an extra step, right, to avoid it. Providing a confidential way for employees to complain, making it clear that retaliation will not be tolerated. Remember that a retaliation suit can be filed if you fail to act. So that could be a form of retaliation, right? That I didn't do anything, so now I'm being retaliated against because my complaint wasn't even important enough, right? So that's something to definitely avoid as well. How would your example be retaliation? Wouldn't that just be discrimination? I thought retaliation was a response to a complaint. And I don't know what example I gave, Joshua. Okay, come back, type in my example and then I can probably follow up because now I don't remember. Okay, so another way to avoid the pregnancy promotion. Okay, it could be, it could be discrimination. It could be discrimination and retaliation go together. So he's asking my example, the pregnancy promotion example. It would definitely be discrimination and retaliation. So it depends on how she wants to file it, right? She could file a discrimination charge, but most likely they're probably going to file both because now, yes, she was discriminated against, but you could also say that she was retaliated against because discrimination is a form of retaliation. If that makes sense. If it doesn't, I can take it offline and explain it to you. But both are very bad and you want to avoid them at all costs, right? So you want to have the documentation, which is my slide here. Really, the best way, I mean, obviously besides educating and having that non-retaliation type of environment, right? It's not acceptable to treat someone differently because they made a complaint or brought something to my attention, right? Is to document. And so any reason for any adverse action, you want to make sure you're documenting that. It could be a verbal, you want to document it, right? So any type of things down below. And usually they are performance problems, so that's how you'll tie them in, right? So remember, there's no requirement to give special treatment to an employee who's filed a complaint. I get that a lot. Well, now he's complained, I'm nervous to do anything. So for example, maybe someone's complained about something and now all of a sudden, but they've been a bad performer, right? Or let's say they've been one and they're continuing to be one. And because they've complained, you're afraid to write them up. So this is tricky because yes, it could be seen as you're writing them up because they complained. But this is where the special treatment comes in. If you have factual examples, right? Subjective examples of how they're not performing. They're being late. They're turning in work that's not correct. They have lost, maybe they're a cashier and their drawer is short. You've got to give specific examples that are tied to the business and their responsibility. And then that's how you have the conversation and you make it very clear. This write-up here is because you failed to show up to work on time. It has nothing to do with the complaint that you gave last week. I want you to be clear of that. We talked about your complaint. I investigated and I found it inconclusive, okay? So until I find evidence of that complaint, then they're separate. That issue is resolved, and now we're focusing on this issue, which is you being late, right? And so to me, you have to have that conversation. You want to make it very clear, and then you also want to document. But you've got to have, obviously your facts, and that's where do not feel that you need to treat them differently. Because sometimes by treating them differently, what are you creating? You're creating an environment where someone who is performing is seeing you treating that person differently, and now you've got inconsistent behavior, and you could have some kind of issue with the other employees who are doing their job well, right? And they're not getting in trouble or whatever. They're being treated differently, right? So you want to be consistent and you don't want to be afraid. You just want to be smart about it. And I think it depends on the situation where you got to choose your battles, and maybe it's something small and you don't want to write them up or talk to them about, you let it go, but you wait till something larger happens, and again, that could be special treatment, but HR is not black and white, so it's very hard for me to say this is how you do it. Hopefully you guys have understood that by now, that it's just a case by case. You want to be as consistent as possible, but you need to apply it to the individual's performance, the individual's seniority, their knowledge, their skill set, things like that. You can't just make it black and white, right? Unfortunately, even though the law wants us to, it is very hard to do that. So remember that. And then of course, remember, as we talked about, to make sure that you're consistent, right? And you want the discipline to be pretty consistent across the board. You also want the discipline to match the offense, right? So, if you suspend someone for, a no-show or whatever, or for doing something wrong, you want it to be pretty practical. You wouldn't suspend someone for 2 weeks for, calling out, a couple days or whatever. You want it, again, the consequence to match the offense, right? And of course, making them similar to what other people have experienced. So what is your defense against retaliation? So the employer must show they have provided a periodic sexual harassment training. So again, this is where that comes into play, right? That you've provided sexual harassment training, harassment in general, retaliation, whatever the situation is. The employee did not suffer that action due to whatever the situation is, right? And so really you have to prove that you really took care to prevent and promptly correct that harassment, and that the employee unreasonably failed to report or otherwise avoid harm. So going back to that example of where you didn't realize someone was complaining, right? If you didn't know, you didn't have the opportunity to fix it. So your defense would be, hey, I didn't realize, but now that I do, I'm definitely addressing it and speaking about it, and going to, take ownership of it and, prevent it by training, correction, whatever the situation is. Coaching managers. So, why are some managers reluctant? Well, definitely it's uncomfortable, right? You've got to have these conversations that are usually confrontational. They're usually about somebody that did something inappropriate, or, sometimes they're just performance-based, and you've got to tell someone that they're not doing their job right, which to some people is really uncomfortable. They don't have the skill set, things like that. So it's uncomfortable. A lot of managers just don't know how. Most of the managers are usually promoted internally because they did their job so well that now they're a manager and they can oversee that, right? But we're not trained on how to be a manager. And so it really is a skill that is learned. It can be taught, but it's something that you really have to keep being in a situation that allows you to give advice and practice it and apply it, right? You've got to hold people accountable. You've got to lead by example. These are all things that you can say you can do, but until you walk the walk, it's a different story, right? So we want to make sure that, we definitely train them on how to do it. They're unsure of the proper steps with reporting harassment. And then obviously a lot of them are worried about being accused themselves. They're so afraid of doing something wrong that they don't do anything. And that's the problem. And then the other flip side, why don't employees tell us? Like, if I'm being harassed, I'm going to say something, right? Well, not always, because it's embarrassing. It's humiliating. Hey, it's risky, right? Like, we've all talked about this retaliation, and it does happen. People do get fired because they make complaints. It's unlawful, yes, but it happens. And hey, you're out of a job, right? And that's your livelihood, how you support your family, yourself. And so a lot of people will not take the risk. They'll be like, you know what? I'm going to put up with it. I'm going to get a thick skin, and I'm just going to deal with it, right? And unfortunately, that's where a good manager comes in, that they hopefully will see those signs that we talked about earlier, and they can say, hey, Amy, you've been acting a lot differently. I noticed you've secluded yourself. Your performance isn't there. You're not focused. What's going on? Can you talk to me? Do you want to talk to me? And just leave it at that. And you open the door, right? So those are some of the reasons why employees do not report it. All right, we're on the home stretch. Prevention. How do we prevent it? So we talked about, all the other things, but really, what do we do? And it's two things. It's creating a policy so that you as a supervisor know what that policy is, and your employees know what that policy is. So what's appropriate, what's not, what do I do if I'm harassed, who do I go to, what can I expect, right? That's a policy. And then the second thing is be proactive. And we've talked a little bit about that earlier, where to me, a good manager is looking out for things that they can prevent from happening. And if they see inappropriate behavior, they see these signs of someone maybe going through something, take the time to establish a relationship, build trust and credibility with your team. And yes, it takes time. It takes a lot of time to get to know your employees, right? I know you're there to work, but you know, we're all human and we want to get to know people, right? We want people to say hi to us, understand who we are. And so by being proactive, you can do that. And then hopefully they'll come to you with issues and you can resolve them before they get escalated to a claim or a charge or something like that. So a couple of examples of what a good policy looks like. It obviously says it's illegal, it won't be tolerated. There's a complaint process. Usually it says, hey, if you're complained or if you feel like you're being harassed or attacked, please go to your supervisor. Within 7 days, you'll get a response. If you do not like that response or you do not get a response in 7 days, now you go to the HR director, right? Something like that. That's usually what it looks like. It talks about disciplinary action that doesn't violate the policy, or sorry, disciplinary action for anyone who does violate the policy. It talks about confidentiality, what the definition is, some examples. In California, it doesn't have to be motivated by sexual desire. There's an investigation procedure, the anti-retaliation, etc. So a lot of this is California, where they just actually renewed or revamped theirs, I believe in 2016. So last year, they came out with a new definition that all the posters have and all the handbooks have to be updated. No touch policy. So tell me a little bit, I know I don't have a lot of time, but get some engagement. What do you guys think about no touching? What type of policies do you have about no touching? Do you have policies that say no touching? What do you think about that? No one's typing. There we go. I think it should be enforced, okay? It's always the safest bet, I agree. Anybody else have anything to share? So in the US, it says, you know, you should grant, this is obviously just, you know, a best practice, right? 1 to 2 feet of personal space. It's hard in our business. We've tried, absolutely. So I come from an environment where we hugged. Our motto was, when in doubt, hug it out. And I personally am a hugger. I'm very touchy. Like it's kind of weird because I'm in HR and I know that it can be very uncomfortable, but I have a habit of going up and like putting my arm around someone and saying, hey, how's it going today? Or touching their arm and all these things that I talk about, right? That can make someone feel uncomfortable. It's a touchy subject. James, you're so funny. So it's definitely something that I think as a company, you have to establish what you feel is right? What's comfortable, what works for you, what doesn't. And just know that if someone says, well, he touched me, you know, and I think it's like, well, what does that mean, right? Because touching could be several things. It could be just something on the shoulder, or it could be I grab someone's butt, right? That's obviously inappropriate. So having a no-touch policy is always really good, but my thing to you would be, if you have that policy, you better enforce it. And it's probably very tough, so it's probably better to not have that policy, right? Just have a more broader definition of touching and what's inappropriate and what's not. So obviously, going back to prevention, it's important to have training. Why is it important? Well, it provides information to you that you may not have received before or known about. It obviously creates awareness. We're talking about it, so we're having conversations. We're being maybe challenged with ways that we're thinking and the way we respond and the way we act. It takes away the you know, the scarcity of harassment. People are always scared to talk about it, or it's so private or personal or uncomfortable. And I think by us talking about it, that takes that away. And then of course, lastly, it's for you guys, right? Because you do play a critical role. You have to be held accountable. And so by that, I need to train you on how to be accountable, right? So with that being said, you're trained because of all the reasons we talked about. One, we're obviously legally obligated, but it's the right thing to do. We want you to represent us, right? And you're the front line to the employee. You've got a lot of power, and what you say holds a lot of weight. And we're looking to you to be that example, that, you know, change advocate of, you know, this is the way our culture looks like, this is what we believe in, and here's how we behave and treat people, right? So because you have all that responsibility, it's obviously very important that we train you. Maintaining trust. So these are some of the ways that we're going to talk about that you can prevent it, right? So we've talked a little bit about your style of management, and I'm a big advocate of getting to know your employees. You know, you should know their if you can, know their families, name, the children, the wife, birthdays. Like, I mean, I know it's a lot of information, but just something that of interest. That way you can have a conversation with them, right? How was the weekend? How was that birthday party? Your daughter turned 4. What was it like? And just being able to dialogue and get away from the work, day to day. You need to be able to put that personal hat on as well, because then you're going to have, hopefully you've developed that type of relationship where they'll come to you and let you know, again, if there's an issue, so it doesn't get escalated to somewhere that you can't drag it back down and maintain it, right? So that's being said is our proactive management. So it's obviously initiating change rather than reacting to events. And a lot of times we're always reacting, right? And it takes a lot of time. It's a lot more work. It's a lot more headache, more documentation to be reactive, right? And then how do you do this when it comes to discrimination and harassment? Well, I'm going to give you some examples that are the most common, but really it's just by having your eye to the ground and watching your employees, being aware of things, changes, all the things we talked about, right? Seeing behaviors that are inappropriate or shouldn't be in the workplace. And that's kind of what we're going to talk about next. So these are the ways that you can be proactive. So what do you guys think? So it's important if you see gossip in the workplace. This is very common, right? There's gossip, someone's talking about someone else or someone's sex life, people are dating, depending on what your culture is. I worked for an establishment where everybody was sleeping with everybody else, and that was the culture, right? And it was super awkward. And so this was exactly what my life was. I had to remind people that gossiping was a form and could be a form of sexual harassment. So yes, people are volunteering this information, you as a manager should put a no to it and say, look, this is not appropriate. It makes people feel uncomfortable, and I get that you want to share your sex life with everybody, but please do it outside the workplace, okay? And, and I would write them up for it because it's inappropriate. It's not something you do at work. Obviously, be aware of your own behavior. If you're contributing to this, if you're participating, that's not going to go anywhere, right? You're not going to establish that credibility, that trust. They're looking to you on how to behave, and they're also looking to you to see how you discipline. I feel like it's almost like children. Now that I'm a mom, I feel like I really get this a lot more being a manager, because it's really about being consistent, and it's about the way I behave on this situation. My daughter's watching me to see if I'm going to do it again, right? And then, hey, I let her get away with this, but I didn't let her get away with that. So now she knows how to behave, right? She knows where the boundaries are. And it's the same way with employees. They're going to watch you to see how you behave, how you conduct yourself, and how you address something. And so you want to be aware of that. Inappropriate dress. So here's some images, right? We have some tight outfits, short skirt, we have a t-shirt. So again, I have been brought, into conversations about inappropriate dress. What do I do about it? Can I really tell an employee how to dress at work if I don't have a dress code? Absolutely. The answer is yes. And I don't think you have to have a dress code. It always helps. But I've had this happen to me where I had a very young receptionist, and she was very voluptuous and curvy, and she wore revealing outfits that showed her cleavage, and she enjoyed that, right? And of course all the males enjoyed it because I was in a male dominated environment, and it was brought to my attention that it made some of the women very uncomfortable. So I had to bring her in and tell her that her dress was, while it looked great and she looked nice, right? It's not the type of environment and not the type of dress that you wear to work. And I really think I put a good spin on it where I said, look, you're a young, intelligent woman, and I do not want you to be perceived as someone you're not. I know that you're serious about your work, you're a hard worker, like you are dedicated, and your dress is not reflecting that. And I want you to dress the way you feel, right? And so I tried to make her feel, I wasn't degrading her outfit or making her feel like be ashamed of it. I was putting more of a spin on, if you want to be taken seriously, you got to dress this way, right? And so I think that, I know it really helped because she changed dramatically. And she even told me, like, wow, I've noticed a difference. People are taking me more seriously. They're not leering at me. Like, I feel like a more mature individual, right? So that's kind of the way I address the inappropriate dress. Obviously, if you have a dress code, you go to that and you say, hey, here's our policy. But if not, you can always take that, that direction. What if a guy doesn't wear socks, but girls are allowed to not wear socks with heels? Wow, we're actually having a conversation about socks. You gotta love the workplace, right? The employees bring so much little details. If a guy doesn't wear socks, well, a girl's not gonna wear socks with heels. That's how I would start. I'd say, look, guy, like, let me be serious with you, right? You know, girls do not wear socks with heels. So if that's your reason, it's kind of silly. Tell me why you don't want to wear socks. What is it? And then I would say something like, you know, especially if it's true, right? You know, we've had a complaint that your feet stink because you're not wearing socks. And that's a reason to wear socks. So I need you to wear socks. Something like that. I don't know. I mean, I'm just winging it, but that's what I would say. Anybody else have a suggestion? Put it out there, and I'd love to hear what you would say. Okay, so what is considered offensive at work? I think we all know, I mean, it's very obvious, right? Sex talk is the most offensive thing. All these other things definitely, you know, come into play, but when you start talking about sex, people get uncomfortable. Do they love it? Of course, right? Because I think as a society, it seems like we're very sexually fueled. If you look at our movies, our books, you know, politics, everything, right? Sex sells, but in the workplace, it's not appropriate. It's very uncomfortable. It's unproductive. It's unprofessional. And obviously it can lead to harassment, right? As we've talked about. So keep that in mind. Dating, a lot of questions about this as well. Will I have someone dating? What do I do? Should I have a policy? You know, what do they have to tell me? So bring in your comments if you like, but what would you say? What would I say is, you know, again, it's going to depend on your culture, your environment. A lot of people are okay with the dating. They obviously want to know about it so they can kind of just be aware, especially if something starts turning sour, right? But they know the reality is they can't stop someone from liking each other and dating and falling in love and things like that, especially when we work long hours. That's where we meet most of the people, right? We're engaged in a project, we're stimulated intellectually, and we sometimes meet people that we really enjoy being around at work. So my advice would be, you know, again, it's your policy and your establishment, but it would be like, hey, be a little flex about it, but I want to know. And especially if a manager, thank you, Tim, if a manager is dating an employee, absolutely not. That's where I draw the line, right? Because that could be borderline harassment. That's just asking for a lot of problems and issues. That's where, you know, you can't stop them from dating, but someone has to lead that chain of command, right? So maybe the employee has to be put under another supervisor, right? You got to figure it out, but which is why it's good to have a policy, right? You don't want to figure it out on the fly, but that's where I draw the line, is that you cannot have someone reporting to someone and they're dating, because that could be favoritism, harassment. It's very uncomfortable and it's not appropriate, okay? So, inappropriate behavior. What is the most effective thing you can do? Can you guys throw out some answers for me so it's a little interactive? What is the most effective thing you can do to stop inappropriate behavior? What do you think? What have you done in the past? And it could be one-liners, some of the things we talked about. What works for you? Education, awesome. Address it, love it. Communicate, don't ignore it. Communicate openly. Say something, yes, you have to do it, right? Hold them accountable, address it directly. All the right answers, perfect. All right, correction. So now that you've got a complaint, what do you do? And no matter how big or small it is, really you want to respond immediately. In my eyes, well, especially if it's a small thing, but you want the person who's complaining to felt heard, feel that they're being considered, and that their complaint, no matter how crazy it is, right? Because we, you know, between you and I, we have employees that maybe like to complain a lot, right? And it's hard to bring them in and say, oh boy, it's another complaint. It's like the boy crying sheep, right? Crying wolf or whatever. But you still need to make them feel heard, because if you don't, those are the type of employees that sue you, because they haven't felt heard, they feel disrespected, then they start going, oh, I'm being discriminated or harassed or retaliated, right? They start getting in your head. So we want to respond immediately, even if it's, hey, I need some time to follow up on this. Thank you for bringing it to my attention. I will get back to you in 2 hours, right? It's those types of things. We want to take them seriously. Again, We want to be fair, impartial. We don't want to promise confidentiality. That's very important. We want to make sure that we don't say, hey, I'm not going to tell anyone about this, because legally you have to tell someone if it's a certain, violence or some kind of harassment that's very severe, right? You most likely need to tell someone. And of course, in order for you to investigate, you've kind of got to get some answers and start talking to some of the people, and they're going to know that someone said something, right? So you just want to be as confidential as possible. Only certain people need to know. Be supportive, show empathy, respect, document. And then of course, depending on who is, if you have an HR person, you want to definitely get them involved and report them immediately. What should you say? So again, in my eyes, my philosophy is, thank you for coming to me. I really appreciate your bringing this to my attention. I take these complaints seriously, and if what you've told me is true, it's inappropriate, it's not allowed in the workplace, it violates this policy, whatever, fill in the blank, and I will investigate and, immediately. So at this time, let's talk about it, right? And so you would start asking all the questions. But again, to me, this is your opportunity to create a safe space for them so you can get as much information as you can. You want all the facts, all the details. That way you can go back and do your investigation. So if you're going to be kind of closed off, you're not going to take them seriously, you're going to be hard to communicate with, they're not going to give all that to you, right? And it's going to just be a bad situation starting out. You want to explain what happens next. So after you've talked to them, you want to make the victim aware that this is unacceptable, that I will be doing an investigation, and obviously, if it's conclusive, there will be discipline, right? Which could include termination. You want to go to the offender and acknowledge that the act is inappropriate and it needs to stop immediately. So, again, that's part of the investigation. You have to ask that person who's being charged, right? Did you do this? If they say yes, boom, you're done. This is inappropriate, and depending on the consequence, you could be terminated, but you're definitely going to be written up, right? And again, that's the severity and beyond the whatever you found in the investigation. And then, of course, you want to tell both of them, everyone that you talk to, that you're committed to making sure this doesn't happen again. Repeat offenses need to be brought to your attention, right? And they could be punishable. Like, this is serious. And I'm doing everything in my power to make sure this doesn't happen again. And a lot of questions I get is that, well, do I need to go back and tell the victim like what the discipline was, or the whole party? And no, you don't. I mean, they're most likely going to find out, especially if it's termination. But, in my eyes, you just need to tell whoever, the victim usually, that, hey, I've talked to so-and-so. He said he's not going to do it again. He has been written up. So if you do want to say something like that, you don't have to say what it is, or he's been disciplined. And I need you to tell me if it happens again. But he understands. We walked out of that meeting with him understanding that that was inappropriate, and he promised it would not happen again. But I need you to tell me, right? You don't have to go into he was written up, or he got suspended or whatever. If you want to, you can, but you don't have to. So when is it time to investigate? You get that complaint, and it's kind of like, well, do I investigate? Do I just have a conversation? And it just all depends, right? But anytime the employee knows something or should have known, and there's a possible violation, that's definitely a time to investigate. There's a complaint, oral or written, that needs to be investigated. When an individual or an employee when an employee or a supervisor talks to an individual about a problem, but the employee continually says, I'm not complaining, kind of going back to that harassment situation where, that wasn't the right one. Just for example, I'm just telling you that this is an issue, and it's making everyone feel uncomfortable when Amy tells these jokes, but no one's really complaining, and it's not a big deal. I'm just telling you, right? Well, that's something that you need to investigate. When you see major changes, like we talked about, productivity, attendance, morale, behavior patterns, those are all times. When it's usually too late and you still need to investigate, when an agency starts poking their nose around, you get a letter, you get a lawsuit, usually too late, right? I mean, there's already something filed, but you still have to investigate. But when I say too late, the damage is done, and it's hard to nip it because it's already been out there, right? The agencies are aware. Now there's going to be a formal situation that you have to really go through, and you've got to get all your ducks in a row. And usually you don't have a lot of time. They give you, anywhere from 30, maybe even 12 days, depending on the agency. And that takes you away from your day-to-day. So really, if you can get to the top half of the list, when you see those things happen, that's when you want to investigate. But obviously, the bottom 3, you still need to investigate too, but usually it's a little too late at that point. That something's already happened, right? So a lot of questions too I get is, do I really have to have a formal conversation? Like, what does that look like? And so really, it's going to be the complexity. If it's just a complaint and something small that you can go and talk to the employee about, that it was inappropriate, this is what it violated, and you get to the bottom of it, you're done, right? You still want to document, but it doesn't have to be super formal. But if this involves a long list of witnesses, a detailed or severe harassment claim or discrimination, you're definitely want to involve as many people as you can. You're going to take really good notes, probably have a witness to help you filter through a lot of the information to make sure you're getting it correctly when you hear it, right? And you're going to want to do all those details. And that's, of course, when it gets more formal. And again, it's urgent, right? You've kind of got to drop what you're doing and have these conversations while it's fresh in everyone's head, while the person has let you know that you're taking it seriously, you're addressing it, and then, of course, gathering all those documents and then making sure they're put all together with what you find, what your conclusion is, and what your decision is, okay? Minimizing the legal exposure when you have a complaint and preventing that harassment like we talked about, making sure to treat people consistently, addressing complaints immediately, taking prompt and appropriate action, conduct a thorough, I see that a lot. Like one of them I had, they investigated everybody, they talked to everybody but the person who actually did the deed, right? So there was an issue with someone being treated inappropriately and violating policy, and they had all these witnesses. And I said, well, did you talk to the actual person? Like, what was her side of the story? Oh, no, I didn't talk to her. I just fired her because I know it was true. Wow, okay. Well, that's a problem because that's an inappropriate, not thorough investigation. You have to talk to all parties, right? And most importantly, remember that they're innocent until proven guilty. There's always 2 sides. You guys know that. There's always usually 3 sides, right? There's yours, mine, and this one. And there's always different perceptions and interpretations. And really the way you treat someone through this process is going to really diminish if you treat them respectful, with dignity, you care about it, you do a thorough investigation, you communicate the outcome, you're most likely going to eliminate and decrease your chances of getting a lawsuit. It doesn't always happen, but usually people sue when they feel like they've been unheard, unjustly treated, disrespected, treated unfairly, those type of things. That's when they usually sue. Some other ways, obviously, we want to have a written published harassment policy that everyone's aware of. Make sure it's clear, it's easy to read, you know the complaint procedure. You make sure complainants understand that retaliation will not be tolerated. We train employees, right? So not only are we training managers, but we're also training employees on what harassment looks like. What are the signs? What to do if I get harassed? How it's not acceptable in the workplace, things like that. And then retrain them. This isn't something you just do on a new hire basis. You keep doing it over and over again. And it doesn't have to be long. I do harassment trainings for employees that are like, 30 to 40 minutes. And we just go over some of the details that I went over today, right? And it serves its purpose. So some common mistakes, again, when you're kind of going through the correction policy the correction process, you don't take the complaint, you treat the complaint more like a comment. So again, no matter how big or small, you want to take it seriously. It's not just a comment. I would say something like, what do you want me to do about this? You've told me this and I appreciate it. What would you like to be seen done? What should I do? How would you handle it if you were my situation? And if they say nothing and you don't think it's a big deal, like it isn't a big deal, maybe it is just a comment that was made, fine, I won't do anything about it. Thank you for telling me. I am going to document that this conversation happened, and I need you to tell me if it happens again. But until I know it happens again, I'll take your word that you're okay with it, and I won't do anything. So that's a way you could handle it. Again, if that's something that's very small and not, a lot of details, right? Not a lot of issues could come about it. Other common mistakes, you're not documenting anything, right? You're not communicating how serious it is. You're not doing anything. You're not taking any action. You're not responding with urgency, or you're not correcting the problem. So maybe you've done all these things, but then you're just letting it happen, right? And so of course, those are things that are going to come back to haunt you. Bottom line, you're in the role that you need to know your company policies. You need to know them intimately, so that way you don't mess up something. Like if you're going to say, hey, we're going to investigate, we're going to let you know in 5 days, but it's really 3, you could be on the hook, and that makes you look bad. It makes the employee think, whoa, she doesn't even know the policies, and what else does she not know, and how else am I being treated unfairly? It just kind of snowballs into all these situations that are very uncomfortable. It can get you into trouble. So really understanding your company policies. And then the Department of Fair Employment and Housing Act brochure, that's the brochure that in California, all new hires are supposed to get about, I believe that's the sexual harassment one. There's like 7 of them, right? As you guys probably know. And that's one of them. And that just educates them on the employees' rights. And so it's always good to understand that brochure, because it's part of the agency that prevents harassment in California. So, I'm not going to say that's like the most important thing. I think definitely knowing your company policies is way more important, and you need to understand how to respond to those, but that's always helpful too. So where does HR come into play? Because sometimes HR does all of these investigations, right? And you're kind of taken out of the loop, but sometimes you are involved. And I would say, I think it just depends on the situation. I've had it both ways, but usually it's very helpful when the manager's involved, because they do know intimate details that I don't, if I'm not on the front line or on the property or whatever. And they've seen things, they've had several conversations. It's just always nice to have them partner up. So again, it could be that once you elevate it, they're going to interview, they're going to talk to the people, right, who are involved. They're going to collect evidence, they're going to evaluate, they're going to take the appropriate action, they're going to report and document findings. They could do all this for you, right? It just depends on the situation. I always think it's a good partnership. And most importantly, I believe that a supervisor, a manager, whoever, when they do need to address a problem, big or small, it's always nice to let HR know, because maybe there was another issue somewhere else and it was handled differently. And of course, as a manager, you're not going to know. So for example, maybe there's an attendance policy that's not very clear about how many times you could be out sick, or do you get a doctor's note if they're sick? These kind of things that are sometimes unknown, and there's a lot of different ways you could address it with the employee, right? It's always good to kind of go to HR and say, hey, what's our policy? Can you tell me can you give me the documentation of how I treated this person a year ago, or something like that? So making sure that you get HR involved, because they know the big picture, and they could help you say, no, Amy, you actually did this in this situation. You probably want to be consistent and give the same consequence, right? So just think about it that way. And they also know all the laws, right? So I can come to you and say, hey, wait, Amy, did you know that that is illegal, and that's a definition of harassment? So we've got to dig into that, right? So we know the laws a lot better. HR knows the laws a lot better, so they can help you navigate. All right, so we're winding down. I've got a couple more slides. Just the post-assessment training, things to take away. Really, it's about creating a productive, welcoming environment, right? That, as we learned, is the #1 way to stop harassment, retaliation, discrimination. Be proactive, correct the problem, right? All the things you told me earlier, hold people accountable. So we want to add these: be fair and respectful, act consistently. When you're making a decision, base it on merit, their performance, things like that, seniority, focus on workplace performance, be very objective, and then obviously follow your rules, right? There are rules and policies that your organization has created. You want to follow those. And so through your actions, you can basically show that you disapprove of harassment and discrimination. You and the organization are committed to creating a respectful workplace, and that employees do not need to fear about being retaliated against. This is an open door policy. I want you to come to me with issues, and you will not be retaliated against, right? And remember, you're a role model. You set the example. So, you definitely want to make sure your employees hear that, and then you follow through, right? A couple other things, people say, well, how do I know it's really harassment? Like it's hard to tell, right? So some common things you can think about: would you act this way in front of your child? Would you say that? Would you make that joke or that comment, right? What about in front of your parents? Would you still behave the same way? And then lastly, if you behave this way, would you want to read about it in the paper? Or, on the flip side, if you made a employment decision, if you fired a pregnant woman or you fired someone on disability, or not coming back from FMLA, these are things that are high emotional triggers that can, guarantee a lawsuit pretty quickly. Even though you have all the performance documentation to show this person was fired, due to a performance, it may not be perceived that way. It could be perceived that I was fired because I didn't come back from leave, or I was pregnant, blah, blah, blah. How would you want that behavior to be read in the newspaper? Because someone's always judging you. And sometimes when you think about how that will be perceived by another person, you could stop your action and really think about it and behave differently. So those are things what I do when I want to gutly say, I want to terminate someone. That was inappropriate. Well, wait a minute. What would this look like? Or something like that. So I try to have those conversations with my clients very frequently. How would this be perceived in a court of law? Things like that. How would you defend yourself? So things like that. Last but not least, action plan. Again, just wrapping it up. Have zero tolerance, set a good example, investigate and respond, right? And then educate, because as you guys talked about, that's a way to be proactive. These are all proactive things, right? And so that's what we want to take away. These behaviors, these conversations, these things are going to occur, but the more proactive we can be, the better. All right, so I have a couple other examples, but if you guys need to go, because I think we're right at the 2 hour, they're not a big deal. They're just other examples. So kind of going back to the coworkers, this guy is asking Melissa out, should you intervene? Melissa said no. Is this harassment? I think we all know, that you just have to have the conversation, right? And if Mark is Melissa's a supervisor, that changes it, right? Mark should not be asking out his subordinate, right? It should be a coworker, if anybody. Here's the hugging one. We have a hugging scenario where everyone hugs, everyone's happy with it. Should you stop it? Should you change it? And I think, we got some of the no touching where it depends, right? You get one person in there, you hire them and they feel uncomfortable, you might need to change it, right? Or at least address it. But there's some situations, some organizations that like hugging and they like that friendly, feel-good environment, and they don't have a problem with it. This is one that kind of not a drive-through, but somebody kind of had the same situation where there was a situation that occurred on property that they had no power, they had no control over. It was a third party, and they didn't know what to do. What do I do? What am I held liable for, right? And this woman, my employee was threatened, but I didn't get the individual's name. I didn't get any situation. The way I always handle it is, if you can, send that employee home, like pay him for their time, because if they're shooken up, they're not going to be of service to you, right? And it's the right thing to do. So that's what I would do immediately. I would also obviously investigate, see what I could do to either resolve it or call the police or whatever. And then I would always offer an EAP, an employee assistance program, which we have through AlphaStaff, because that's always a great avenue for anyone, who's having emotional issues, anything big or small, but something like this, it's a great way for them to have an avenue to talk and get their feelings off their chest and any fears that are coming up due to that experience, right? And that's a great way for an employer to make an impact at no charge. Last but not least, kind of going on the gender question, this comes up pretty, kind of frequently, where again, we have the male who wants to dress like a female. So in this situation, there's actually a uniform, and the male wants, because he identifies as a woman, he wants to wear the woman's outfit. What should the owner do? And really in California, I think we all know that, it's not going to impact his business. Well, at least it shouldn't. This is where I get a lot of, conversation going on. But in the eyes of the law, it's not going to impact his business, where the employee can still perform the job by wearing a woman's outfit. Now, my last training I got, well, what if people are offended? He starts losing business. People don't go to the establishment because a man is dressed like a woman. And that's a totally different situation. That's very sensitive, and I do not have legal, background to give advice on that. But just knowing that that's where you'd want to escalate it, right? Because ultimately you want to allow your employee, as long as it doesn't interfere with his work performance, by wearing a dress would not be a problem. So that's how I would respond to that.